Still living.
Keeping warm?
Yeah,
All right.
making our wood warmers twice.
Morning, Steve.
Good morning. How are you?
Well, thanks. As you know, the voice is actually working this morning.
Yes, that's
Yeah,
good. We're making
right in the
progress here.
laptop.
Yeah, that's good.
Uh,
How are you, Roberta?
Yeah, still managing.
Good. Guys have a nice Christmas?
Yeah.
Yeah.
Good.
The neighbor came in and sanded our road for us one day.
Ooh, wow.
The ice. Yeah.
Boy, it's some brutal cold, huh? The last little bit.
Mm.
Even for the time of year, it's wow.
how's the snow been up your way, Steve?
Well, we after that last rain, we got about 7 inches of snow on top. And ever since then, it's stuck everywhere. Like all the trees are still laden. I'm right next to a solar farm. All the solar panels are still covered with snow. Right.
Free
So
electricity.
yeah, it just we had a hard freeze, and it's been like that ever since.
Hmm,
Must be warmer by the end of the week here, but
that's what I hear.
cold. It didn't even hit zero yesterday, I don't think.
Whoa,
It was very, very cold.
that is tough.
Hi, Heather.
Hi, how are you?
The very best, as they would say in New Brunswick.
That's good. It's cold down here.
Yeah, it's cold everywhere, I think, right
It's
now.
gonna be 40 though on like Thursday or something crazy.
Yeah,
Wednesday,
I
Thursday.
heard
I
by the
mean,
weekend. Yeah, I heard by the weekend it's supposed to be milder. Not that warm here, but still a lot better.
yeah, that's crazy.
We'll call it a January thaw.
Yeah,
Well, I remember some winters when never got above 10 below the whole day. And
yeah.
then I remember times when 10 above seemed balmy because it had been cold for so long.
Yeah, yeah.
Morning, Tanya.
Good morning, everybody. How are you this morning? Happy New Year, everybody.
Happy New Year to you. Thanks.
Happy New Year.
You.
We are working our way toward a quorum. Morning, Pete. Morning, Matthew.
Hey, hi.
One more. One more.
Oh, I see Chris.
Morning, Chris.
Hey, Chris, let me be the first one to say congratulations on your promotion.
What's funny is that's 4 years old. But it's an internet site that does clickbait. So, but I appreciate Pete.
Clickbait.
Belated congratulations,
Yeah,
Chris.
yeah.
What's clickbait?
Gets
Oh
everybody to
boy.
click on their website.
Hmm.
It's funny when I first got sent. I think probably 6 months ago, someone sent it to me originally when they first put it out there. I laughed. I was like, "Oh wow, thanks for the." I didn't realize I got promoted.
Take it to HR.
I know. I know.
There you go. Morning, Tom. Well, we'll give it another minute just to folks to join in, and then we'll get started. Okay, let's get going. We'll begin the meeting of January 5th, 2025, of the Abandoned and Discontinued Roads Commission. And let's have a roll call, please. Heather?
Sure. Peter,
Here.
Tom,
Here.
Tanya,
Here.
Matthew,
Here.
Jim,
Here.
Chris,
Here.
Roberta,
Here,
Vivian is out, John is out, Kathy is out, Ryan has resigned, Steve,
Here.
All right, 8 people, so we have a quorum.
All right. We had draft minutes put together for our December 2nd meeting. If you've had a chance to take a look at those, is there a motion to adopt those minutes?
so move.
Is there a second? Okay, Steve. Okay, any discussion? Any corrections or whatever? All right, then let's have a vote.
Peter,
Yes.
Tom,
Yes.
Tanya,
Yes.
Matthew,
Yes.
Jim,
Yes.
Chris,
Yes.
Roberta,
Yes,
Vivian is out, John is out, Kathy is out, Ryan is resigned, Steve.
Yes.
Okay. Motion carries 8-0.
Updates and announcements. I have nothing new to report, but I turn it over to Heather to report to us what she may have heard about the commission's business generally and new appointees, things like that.
I haven't heard anything. I'm following up this week, and I'm hoping because the legislature is back this week, that we get some movement on appointments and things. Obviously, we're on track to submit the report February 1st.
Right.
And that's all I have. I'm going to reach out with an email on those who I'm still waiting for the FOA stuff. I think 8 of you have done it. So somewhere in there. So I have my list. So I'll just individually reach out for people to do the FOA that I don't have, which is not much. It's just reading question and answers and then filling out a form and telling me you did it.
Great.
how much longer is it before our legislation goes through if it gets signed or not?
I'm hoping in the next week. I mean, from what I heard, she was gonna, as soon as the legislature went back into session. My understanding is they're all here today, but I don't know if they're opening session. I think they're opening tomorrow for session, but
Wednesday?
hmm?
I think Wednesday is what I heard.
Wednesday, maybe. Yeah. I don't know. I know it's this week. So we had heard maybe possibly tomorrow. There's some stuff that I think they want to get done, but it probably more like Wednesday, I would think. They're a little slower. They tell me one thing and then it takes longer. So I'm following it. I know you are, Roberta. So, I'll just keep refreshing and checking on the websites to see what's going on with the bill. And I'll reach out to my contact today and see if the governor is planning on signing it this week or next week or hopefully soon.
Tanya, have you heard anything about this?
Not about this particular bill, but they are cramming in public hearings and work sessions very, very quickly. So I think refreshing the calendar constantly is pretty much the only way to stay updated.
It's the second session and stuff happens. They have to get out early. So understood.
And my understanding is they want all the carryover bills done by the end of January. So we have, many, many public hearings and work sessions already scheduled for the first 2 weeks. So it's going to be very hectic.
That's ambitious.
It is.
Okay. Well, then we'll get started on our work then. We have a draft report. We have a report that's due February 1st. Now, because we were working with the legislature on the bill that was passed, and we hope the governor will sign, we really haven't done much else because we're waiting to see what happened with that. And so the report doesn't have any draft legislation, the draft report that we sent around. But what I tried to do is we had a fairly robust discussion at the beginning of December about different items that we might address in the coming year, different topics on abandoned and discontinued roads. And I tried to list those at the end of the draft report as part of the work, the scope of work for the year. So I put that at the end. What did folks think of that draft report? Okay, comments, additions, deletions. There's no pride of authorship here. Just Heather did a rough draft. I did some edits, and we wanted to just get that out there for people to consider. Don't all speak at once.
Jim, I read this once, but I'd like to maybe have 2 more days to read it again just to decipher it and comment to you there.
You're lucky I didn't handwrite it, because then you would need help deciphering it.
I second that. It was a while ago that I read it, and I need to go back over it.
Fair enough. We've just gotten through the holidays. What I'd suggest then is if you look through it, there may be some things that we would want to add as a result of discussions today, or things we'd want to change a little bit. But if you could get comments to me and to Heather by the end of the week, that way we can break in the new year a little bit, and you'll have a little chance to take a look at it this week. If you could get our comments, we can get going on that, and maybe have a quick special meeting just to vote up or down on the report, adopt any changes, make sure that we're all on the same page. Does that make sense?
Okay.
Okay. So review comments to Heather and me by the end of the week. We'll get a clean draft out. And then a brief special meeting just on the report, so we get that done on time. Well, that's easy enough.
Tanya, what's your schedule like? Because I know you had said this month was going to be like really crazy for you. So,
It'll be tricky. Are you thinking in terms of scheduling the next meeting?
well, for the special meeting, I'm thinking like if it's the end of this week for draft comments and stuff, and for us to put together, Jim, probably a week to review the comments and get it together. I don't mean to rush you, but it's February 1st, and I need a few days to get the printer and stuff to get stuff printed out. So
Friday the 16th? Because we're losing the 19th to a holiday.
Is that works for you? Does that work for everybody else if we did a meeting on January 16th? Maybe check their calendars while I have you here.
In the morning, not afternoon.
Yeah.
If I ever suggest a Friday afternoon meeting, somebody should probably call for help for me.
Don't blame you, especially with it being a long weekend. Do you want to? You had said 9 for this morning, but would 10 work better for you, or is 9? I don't. How
Either
does
one's
everybody feel
fine.
about the 9 o'clock start? Would you guys prefer 9, or do you guys prefer 10? So I have you all in front of me.
This is fine with me.
9.
January 16th, and do you guys prefer 9 or 10?
Let's say
Doesn't
9.
matter.
9, and we are going to shoot for a less than 1 hour meeting.
Okay.
Half an hour would
Yeah.
be great.
Yep. Sounds perfect.
Heather,
Okay.
Heather, can you send an Outlook thing so I can get it on
I
the calendar?
definitely will. Yeah, I
Okay.
will. I'll schedule that with Zoom and stuff and make sure that that's all set up.
Okay.
Sorry, I didn't mean to interrupt the flow. I just thought since I have everybody in front of me.
No, that's great. I appreciate that. That's good. All right, the next part, review and prioritize proposals for draft legislation. What I'm talking about is basically a commission work plan for 2026. I had started by listing the issues that we talked about at the last meeting, and that's at page 6 of the draft report. And what I like to do is maybe work from that, but then go over to Roberta's comments as we talk about those issues, and get those on the list. And some of them already are. And then John Monk had sent an email that followed up on one of Roberta's issues in particular. So the first one and it's the one we discussed first at the last meeting, was should a landowner or a municipality or a county have the authority to allow use of a public easement by an ATV operator? Basically, we understand under law, the ATV operator is supposed to ask the landowner for permission to use the road if it's not a marked trail. Is that an accurate statement, Chris?
Correct.
Okay. So then the question with a public easement is, who do you ask? Is it the municipality that has the authority to watch over to allow public access to occur? Or is it the person who is the landowner and owns to the center line? Is it both? What happens in the event of disagreement? So maybe clarity on that issue. I'm not trying to get an answer right now, but that seems to be a live issue, and one that's difficult for people who are managing ATVs, who are regulating them, to try to come to terms with. Is that an issue that should be on our list?
I think definitely it should. There's a lot of confusion on that issue.
Okay.
And there's confusing statutory language.
Confusion is our calling card. We're supposed to
It is,
address
isn't it?
confusion in the law and try to
Just
make it all go away.
abandoned roads, you could just define it as confusion.
Abandoned and confusing roads. All right.
One thing that I think ties into that is the suggestion to somehow get towns to do an inventory of their roads. I know there's been a lot of resistance about that, but it's been on the radar for a long time. MMA's staff attorney Wathen recommended it back in the 1990s, I believe, and there are some towns that have done it. And if we can get that information someplace where people can access it more easily, whether it's somebody who's looking to buy land, or whether it's law enforcement, or a couple of landowners that are having a dispute between them, if that information can be found more easily, I think that would help a lot. There's still the question of who actually owns the easement. Is the landowner the owner of the easement, or is the public the owner of the easement over the land? And then I say, if you go by the layer cake theory, if you can use the easement over the top of the dirt without disturbing the dirt, fine. Snowmobilers don't usually do any damage to the dirt. But when you get to people with big 4-wheel drive vehicles that want to come through during mud season, you can't do that without disturbing the dirt underneath. When you get ATVs, that there's always that rogue rider who goes out while the trails are still closed and tears things up. They're no longer using the easement over the top of the dirt without disturbing the dirt. So I think that's what the issue is.
I think 4 and 5 kind of get to that, and we could include that as part of 4 and 5 when we get down to those on the list. But you've mentioned that topic, and John Monk has joined in that idea, and I think we talked about it last year because that was part of our charge. To talk about where information about roads should go and who should be the repository, and everybody was pointing the finger at another agency, but away from it itself. And I understand.
When it comes to where to deposit that information, I got in touch with someone that I know on the registries of deeds, and kind of suggested that idea to her, and she said, oh, she thought that was a great idea to have it have an index of where these records can be found in a binder at the registries of deeds, same as they do for county roads. And she said they're having a meeting this week, and she's going to present it, see what the other registers think of it, and then they've invited me to come and speak to them next month, and maybe we can work out where that information could be kept. I'm not talking about interpreting the records. I'm not talking about, figuring out what the records mean, just find where you can find the record. Where's the book and page number where that record can be found? And then if there's a question or a dispute, the town can flip open the book, say, yep, it's on this page, this year, pull out the record, hand it to them, and they can take it to their attorney if they need to find out what the actual status of that road is.
Mm-hmm. Yeah, if there's an order of discontinuance that's been recorded, if there's an order with regard to statutory abandonment, a vote taken by the town, and it's all a matter of public record, there's no harm in having someplace to look and find all those on a centralized basis. And once that gets established, then it might be easier to put a disclosure requirement on real estate sales of such records that somebody has to look at that index. But we can't get there until we start talking about indexing and who's going to do it. And if the counties, the registries are willing to do that, great. I would like to see what an example of a page or two of what's there for county roads now. What does it look like?
I can show you that real quickly. I think I can share my screen. If I go to the right website here, it should take me just a minute to pull it up.
Chris, you had your hand raised. Did you want to say anything in the meantime? And then
Yeah, I
Matt,
was
you
just
raised your hand raised.
and Matt will probably chime in on this, but I will say that I do think that it's important to just have recreational vehicles as a totality and not just ATVs, although ATV law requires you to have landowner permission to operate on. Snowmobiles we have the same issue on these discontinued roads with public easements because we do have landowners that want to shut down the snowmobile trail. So I think the clarification on like where you get the permission from for just all recreational vehicles is very important. Not just ATVs in general, it's snowmobiles also. We run into that quite frequently, and I don't know if that's what Matt wanted to talk about too, but.
Sure, we'll get to, and Matt will call on you in just a second. But Chris, one quick thing: if we were to also be including snowmobile trails, known trails, and ATV trails with that inventory of roads, is that something that would make sense?
I agree. Yeah, I would say because, and Matt knows better than I do, but the clubs work very hard on snowmobile trails even to get landowner permission to put the trails across because they have to sign into an agreements with the state anyway on these trails. Usually if there's a trail that's a club trail or just someone's local trail, that's when they don't have permission from the landowner. But the only reason someone can ride a snowmobile anywhere without permission is if they're just riding out in a field until they're told not to be there. But that's just the statute. But the trails all have permission to be there. So I do think that would be important to have that.
Okay, Matt.
Yeah, I was just I know I'm kind of new here, but I'm not new to municipal government. I was in it for 15 years and have dealt with a little bit of this on the other side of it. And the biggest thing that I see is just the towns clearing it up. But I was kind of looking for some feedback from Miss Emery here on, because I always heard the term unfunded mandates and everything else forcing things onto municipalities without providing funds or help to take care of it. But, just being kind of devil's advocate and wanting to hear a little bit of what Ms. Emery thinks about this is like with my background in the municipality that I do feel like the municipalities have kind of put an unfair burden on taxpayers by not properly handling these roads when they've been discontinued because it was the authority of the town to discontinue roads and maintain and to do it properly. And I think that the biggest thing would be just having towns be required to just clean up how they were abandoned, whether they were abandoned with public easement or not. And then I don't know that we really need to call out any specific types of recreation because I think public easement just means public easement, but I guess it could include motorized or non-motorized, foot traffic only or something. But I was kind of curious from the MMA perspective on how that's going to fly legislatively if it's a recommendation from us that municipalities kind of clean up something that I think is their responsibility and something they should have done right in the first place, and now is kind of a burden on the taxpayers that they're supposed to be serving.
Yeah. I'm happy to add what I can. I think with the caveat that I am also still very new here, but I think the immediate concern that I have is that this does sound like an unfunded mandate. And if it is a mandate, there needs to be 90% of the funding of the cost of what it's going to take to do this. And the biggest challenge is just going to be municipalities right now are being asked to inventory a lot of stuff like building permits, housing creation, demolition structures, all those sorts of things that are pretty high priority. And some of those are a result of new legislation. And that's going to create a pretty significant squeeze on smaller municipalities and larger ones as well in terms of getting that work done. So I think it needs to be thought through in terms of how really, I think for MMA, a lot of these things, the devil is in the details. And if there is an agency that can help with GIS layers, if there's a way that this can be facilitated, I will say Maine Office of Community Affairs is really becoming the hub for technical assistance and support and resources for a lot of those municipal issues. And so it might be worth a conversation with them, but they are so focused on some of the housing and land use issues that have been coming out of the legislature that have been implemented that I think it's going to be a real struggle to get their capacity to work on this. But I do think if we're going to make a recommendation like this, it needs to be thoughtful in terms of how would it actually happen? What's a realistic timeline? What are the resources that would be needed? We don't have to take it all the way to the, nth level, but I do think we need to think through some of that because it could fall flat if it's an unfunded mandate, because there would have to be a fiscal note. And if anybody's a real lawyer, please tell me if any of that's wrong.
It's not wrong, and as the guy who did the research to put together the unfunded mandate law 40 years ago, I appreciate why it's there. On the other hand, what Roberta and John were talking about is that municipalities, many do have road inventories, and if it's something as simple as give us a copy of what you have.
That's easy.
That's not going to be the biggest unfunded mandate to come down the pike.
No. And that typically wouldn't even raise any eyebrows. It would be all the towns that don't have one, or if there's a prescribed format or data that's missing, and then municipalities that have an inventory have to go get it. And I just personally have a real concern about, we keep trying to ask municipalities for more and more and more data, and many of them don't have GIS databases. They don't have parcel level data. They don't have any of this stuff electronically. And that creates a real disparity in terms of what communities can report and share this information, and where residents and taxpayers can expect to get it and where they just can't. And that gulf is only going to get larger, I think.
Right. No, I understood. Okay. But I think that's something worth talking about. We're not going to resolve it this morning. Let's put that on the radar screen. And that's really a combination of 4 or 5, an inventory of roads, and also recreational vehicle trails. So that the idea is that there's a better resource for people to be able to check the boxes to whether they've looked at how they're going to get to and from their property and what the status of is that, if it's known. We're not asking anybody to go out there and file a declaratory judgment action in order to be able to tell us what every town and what every road in town is like. But if if there's an order of discontinuance, if there's a vote on statutory abandonment, these are all public records. Let's make it easy for that information to be put into a database that can be used by realtors, that can be used by attorneys, and people at least know what's publicly available. Tom.
I thought Matt actually brought up one of the issues that I think has caused one of the biggest problems we have is there are roads that were clearly public town roads, but nobody really knows the status now. And for whatever reason, the record's lost or something. And I thought Matt raised a good point about usually in those cases where there is no clear record, it's left up to the landowners to fight it out. And that's been one of the frustrating things about it was a town road. I mean, I don't think there's a dispute. It was a town road. What happened to it? It was the town's. What did they do with it? And often the answer is we don't know. We don't know. So you're on your own kind of thing. And that's been one of the frustrating parts about trying to solve these problems, because now it becomes 2 landowners suing each other to go to court to decide the status of what the town actually did with the road. And that's been one of the frustrating things. So I'm not sure there's a great solution to it, but that's been part of the problem in the past.
I agree.
Something we
'Cause
need to think
that's
about.
that's when they call us and they want us to get involved, and we're like, this is a civil dispute, and there's really no course for us to take other than tell them that. So we kind of we get left in a hard spot, and then it leaves landowners with a sour taste in their mouth.
Roberta.
Yeah, I posted in the chat a link to the county record book that I'm talking about. Hancock County Registry of Deeds very kindly digitalized it and posted online where everybody can find it. I can also share the screen, I think, and show you what a page of it looks like. Let's see if this works. Yeah, this is from the county book, and I'm not picking on these towns in particular. I just grabbed a page, but you can see it has the name of the town. Then it has what county it's in. That code number indicates the county. They're numbered from 1 to 16 alphabetically. So the A's come first. New York County comes last. Then it has the volume of the county commissioner's records, and then the page in that volume. And then D signifies discontinuance. C would signify closing. L is a layout. P is a petition. And then it has the year. And then sometimes they're able to put in the name of the road. Lots of times they say not located because they weren't able to tell from the description where the road was. But at the time they did this, it was back in the late 1970s, early 1980s, I believe. They didn't have all the online resources we now have. So sometimes, if I'm lucky, I can go back into the records and say, oh, this has names of the people at each end of the road segment that was discontinued. I can go back in the registry of deeds and find where those names were. Sometimes track down where that exact section of road was. Or sometimes one of the techniques that the surveyors at the DOT used was they would actually draw a scale drawing of the layout of the road. This book doesn't have the layouts. I have on flash drive the rest of the book that has all the layouts in it. So sometimes I can take that layout and draw out by how many degrees, how many rods, get a sketch of the road. And then what the surveyors at the DOT would do is they'd take that tracing and orient it to true north and slide it around on a map until it matched something. And sometimes I can still do that and occasionally find where these not located roads are. But this is something that if towns knew how to do it, maybe they could make a list of their roads that would look similar to this. It would have the name of the town, and then in the case of a town, it would be the year of the annual meeting on which the road was acted upon, and then the number of the warrant article that acted upon it, and then the result of the vote, whether it was voted yes or no, and just a brief description of where the road was, if known, or the name of the road. And then anybody who needs it can just look at the book, say, okay, I need a copy of this. And this is what I do when somebody comes in with a request about a road. If it was a county road, which I can tell by going to the DOT map viewer site, then I can get these book and page numbers, and I send a request to my contact in the Division of Rights of Way at the DOT, and he will send me a printout of that discontinuance. And then I can say, yes, this road was discontinued and they didn't keep an easement over it. Or they did keep an easement over it, because one way or the other, that will be in that record, if I can find the right road. But this is a good start, and the registries of deeds have found this very useful when somebody comes in and asks about a road, if it was a county road. But if it was a town road, this doesn't help at all. And that's where I'm saying if we had something similar for towns, I say just start with the ones you've got. According to that survey that was done by MMA a number of years ago, I think it was 2012, I think, or 2017, somewhere in there, they determined that I think it was 44% of the towns that responded to the survey said that they had already done or at least begun an inventory. So if we take the ones we've already got, that's a starting place. And then for the other towns, I start with the easy ones. They know which roads they maintain. They have to report that to the DOT already. So start with those, then maybe add in private roads they have to list those for E911 and then start picking away at these discontinued roads. I think a lot of it could be done by volunteers since they don't have to interpret what it means. All they have to do, I on a regular basis have people go to the state library with me and I show them how to do this. We ask the library to bring in a collection of the town reports for a town, and we just sit there and we go through the warrants in each one. And anytime we find anything that has to do with the road, even if it doesn't seem to be the road they're looking for, I say, write it down anyway, write down the date and the warrant article, because you may find out later, oh, you saw one for Smith Road. Now it's called Jones Road. You didn't think it was your road, but guess what? It used to be Smith Road. Or your neighbor comes and says, hey, I know you did some research on your road a while back. How would I find out on my road? And you pull out your book and, oh, I've got your road here already. So you just, all it takes is a volunteer to go through and look for those road articles and just write down the year and the warrant article number, and make a list. And that's where you get something like this.
No, that's good. That's helpful to know how the counties are, or how that county is listing this, and at least gives us a starting place to look at this, and then we can talk about how the information gets there and you know who does it and later. But at least let's figure out what we need to see what the counties are doing and take it from there. So right now we're at the 40,000-foot level, just trying to figure out what should be on our work plan for the year. Clearly, this idea of a road inventory, trying to collect what's out there now and get it in an order that's going to help people, will be something that's worth discussing. The second item on my list is something that Roberta had brought up several times, and the idea being that we know that municipalities can't spend public funds for a private purpose. So municipalities can't pay to plow nonprofits' driveways or individuals' driveways and all that using public funds. The concern Roberta has is that private individuals are spending their private money to maintain public easements where municipalities don't, and they're doing that because that's their access. And so Roberta has asked whether the legislature might declare a solemn occasion, which is what it takes to go to the state Supreme Judicial Court to talk about the constitutionality of proposed legislation. And so this is what Roberta is asking for, to take a look at the issue of public easements generally, where private individuals are maintaining the public right of access at their own expense, and there's no public maintenance that's required. Without presupposing how the commission feels about that, the question is, should looking at this be part of the work plan for the year?
Well, of course, I would argue that it should, because this really is the heart of the reason this commission was formed in the first place, was because this issue keeps coming back up again because people keep having problems with them. You buy a piece of property, maybe even knowing that it's on a discontinued road, but what you're told is, oh, the town has nothing to do with that road anymore. So you think, fine, I'll rebuild it for myself. That's no problem. You rebuild it for yourself, and as soon as you open it up, the public says, oh, look, we can use that road again. And the next thing you know, they're tearing it up faster than you can keep up with it. And it's just a constant burden. You're throwing money into an endless pit, because as fast as you maintain it, somebody else comes and wears it out. And that's where the big problem is with a lot of these roads. And the flip side of that is roads that were discontinued with no easement remaining, and people find they're landlocked. Maybe when they buy it, everybody's using the road, and then somebody else comes in and buys property on both sides of the road and says, okay, now I own the whole road, and they block it off. So those are the two big issues at the heart of why this commission exists.
Yeah, Matt, I'd encourage people to, if you have a comment, just speak up, because the chat function is something that I know a lot of we advise our clients not to be using for municipal meetings, and I think let's just bring up the issue. But I think before Matt, I understand your concerns. There's a tension here, and the tension is that, and we'll use Roberta as an example. And I know it's Fayette. I'm not picking on Fayette, but just as a concrete example. David Manter purchased property on this road in 1974 and asked if there were any, 71, I'm sorry. Okay, I knew it was the early 70s. And asked what the status of the road was at the town hall and before he bought. And no one appreciated that there was a discontinuance and retention of a public easement. He thought it was a private road. That things happen. I mean, nobody can rely lawfully on what the municipality says. Everybody's doing their best in an uncertain situation to give out information, and it isn't always right. There is a public easement there that was retained, and the problem is that, while no one is required to maintain a public easement, private individual is if the town doesn't. If that's the access to your house, somebody's going to fix it. And that's a person who owns the private easement, or the person who has the access on that easement, under the courts have said individuals can maintain a public easement. And that's the road. And the reason that you don't have a private easement in that situation is when the lot was created, there was a road there. There was a public road. And so, there is no private easement to get to your house. There's nothing else to maintain. There's no other right to maintain. So the Manters are benefited by the fact that there's a public easement retained because that's the access to their house. They can get to and from their house, and they can maintain it. The courts have said you can maintain a public easement. But they're also burdened by the fact that it is a right of public access. So the logging company, and I'm not picking on loggers, I'm just using it as an example. The logging company that owns woodlot beyond their house, the truck has a right to use that public road just like everyone else. And so do the people driving an ATV if they've got permission from the landowners, or using a snowmobile, or driving a pickup truck, or a super heavy mud runner. But the super heavy mud runner might dig up the work that David and Roberta did in order to get to their house. That's the problem. That's the tension. They're benefited by the public easement, and they're burdened by the public easement. And so that's the thread we're trying to, well, that's the narrow thread we're trying to navigate to try to get everybody on the same page. Roberta's contention has been that that's unconstitutional to make them fix that public easement. But if it's important enough to the town to retain a public easement, then it ought to maintain it, I believe, has been the argument, especially where there are rights of public access. Why should a private landowner have to do that? On the other hand, the comeback is, well, look, if it weren't for that public easement, you wouldn't be able to get to and from your house. So that's what we're navigating for issues here. And so that's the question is, Roberta has asked that we take a look at that. Is that something we want to put on our work plan for the year to discuss? It doesn't mean we will recommend something. It doesn't mean we won't, but to discuss.
I'm okay with discussing. I guess I have an issue with the word required. That private citizens are required to maintain it because they are not required. I guess that's my only issue, but I'd be happy to discuss.
I can reword that to say private landowners having to maintain the public easement at their own expense for public use. I say having to be in order to have access.
Right. I mean, because I would say I'd have an issue with even saying that they have to, because that's almost sounding like required because it's not. But
yeah, in order to utilize the access. Okay, so is that something we can agree to discuss it? Okay. And then this maybe goes to the cleanup part. Should public easements be eliminated where there's no longer a need for public access or a private road association can maintain the way? four or more landowners in an area can create a private road association, as we know. And usually that happens on a private road. But if a municipality hasn't been maintaining it, there probably is nothing that would prevent a road association from being formed along a public easement. So in that instance, if a road association can come into being, can they petition the town to discontinue the public easement? Say, we just want this to be a private road and we'll take care of it. Roberta, I mean, I think they can do that now, but.
This all goes back to the fact that in 1970, the year before my husband bought the property, there was a Maine Supreme Court case. Had to do with what was called the limited user highway law. And what that law said was that when the selectmen of a town determine that a road is of limited use and value to the traveling public, they can declare it to be a limited user highway. And from that time forward, the town is no longer responsible for maintenance. They're no longer liable if there are any defects in the road, but it remains a public road and is not discontinued. And the public still has a right to use it, and the abutters can maintain it if they want to on a purely voluntary basis. But the court said that there's no guarantee that the abutters will maintain it, and if they did, they're spending private funds for a public road, and they are going to lose access because the public's use will inevitably destroy the road. And they declared the law to be unconstitutional.
Yes.
Well, what they said was unconstitutional was a public easement of travel with no public maintenance, and that would inevitably destroy the road. And that's exactly what we've seen. When you have a public easement of travel with no public maintenance, it destroys the road.
Which means that public easements, as we know them now, are public easements of travel with no public maintenance, which makes it unconstitutional. Start with that.
And what we have now in public easements is exactly the same thing. That case even said that it doesn't matter what the legal status of the highway is. What matters is the practical and factual consequences of the governmental action. And that in some cases, the landowners could be without remedy. And that's exactly, almost word for word, what we have now. And we can't figure out why that was unconstitutional and public easements are not unconstitutional when it's the same thing. That's what needs to be looked at to see if this is something that the court will make a declaration on, because we don't see how you can have the same thing and have it be unconstitutional in 1970 and not unconstitutional now. If we can get them to look at it, maybe we can straighten some of this out. As for having a road association maintain it, you still run into the same problem, which is that whether it's one person or a bunch of people maintaining the road, they're still putting private funds into a public benefit, keeping that road passable so that the public can use it. If we had to keep it passable just for us, that was a fairly simple matter for the first few years we were here. But once the road got opened up, other people saw that they could use it.
And they could sell their land and give it.
Yeah.
Roberta, I'm going to interrupt. If David wants to submit a public comment or give a public comment at the end, that's fine. I always appreciate his comments, but right now, while we're having the commission meeting, if we could just have the commissioners speak, and then at the end, if he wants to talk, he can.
You're hearing 54 years of frustration.
I know,
We
and I
appreciate
understand,
that,
and I appreciate that, but I also want to keep the meeting on track, because I know some of the commissioners have certain times and they have to leave at a certain time. So I want to make sure we hear you, we get through all of the points, and that everybody hears what you're saying. And then the public comment always comes at the end. But as he's not a commissioner, I'd like, if he could possibly wait to the end to give his public comment, that's fine.
Okay, just to sum up, even if you have a road association maintaining it, you're still putting private funds into maintaining a public road. And the better you make the road, the more people use it. Maintaining it for our vehicle isn't a problem, but maintaining it for 80 to 100,000 pound log trucks and mud runners and ATVs and boonie cruisers, and the fact that people clear their land and then sell it for development, and now we have other residents on the road. And you have all this use of a road that we just can't keep up with.
Okay. Tom.
So I think what you were getting at, Jim, was the idea of there are roads that where there's a public easement that the municipality ought to consider that extinguishing the public easement. I think that's
Correct.
the concept, right?
Correct.
And my personal experience is that very few of these public easements serve a direct public purpose, meaning they go to a public property or they're critical access for some high public use area. That the vast majority of these are basically the access for people to access their property. And so I do think there's a lot of opportunity to get out from under some of these. The towns were required to keep public easements for a long time. And so they're on the books, but if you already have, if they serve no public purpose and you have an agreement with the landowner, so you're not landlocking somebody, then it seems to me that you should extinguish these public easements. And that would resolve a lot of these issues because what then happens is everything's going great. Everybody's helping each other that needs the road. And then suddenly a town says, oh, we're going to let the ATV club now make it an ATV trail. And so suddenly the whole thing changes. When it really wasn't ever meant to be an ATV trail. It was, you had something working and all of a sudden everybody's using it for some other purpose that was not intended. So I think if you could get rid of these public easements that serve no public purpose, where there's already nobody being landlocked or there's going to be an agreement, I think you'd solve some of these more difficult or avoid future problems. So I'd like to get that on the list.
Okay. Matt?
Yeah, I mean, I somewhat agree with Tom on cleaning some of that up, but looking at it from the municipal side, you really have to look at the future. You can't, it's really tough to give up assets and roads and properties that you may need in the future because a town never knows how they're going to grow, where they're going to expand to, where new areas need to be developed as residents move in over the years. Because as a municipality, you really have to think the long term. You can't really just think about, let's just clean up this little issue right now. When you're thinking, how do we know 50 years from now we're not going to be a boom town? We're going to need that public easement because we're going to have to spend tons of money later to get it back. Because it's hard once you get rid of something like that, it's hard to get it back. So I think I do agree in a sense with Tom, but I do think the flip side of that, the reason why municipalities tend to keep the public easements when no one sees any benefit is because it's a benefit for future growth for the town just to have it. It's an asset. It's a huge asset to have, and a problem that you're going to run into later when all of a sudden it's like, what are we going to do? We got to expand.
Well, yeah, and there are really two reasons why municipalities have favored the automatic retention of public easement, which has happened since 1965. And one of them is so that you don't landlock anyone. But another is it reduces the amount of damages you have to pay. I mean, you can pay $1 damage because you can say it's still a public right of access over it. We just don't have to maintain it. If you took away all rights, as the law was presumptively before 1965, arguably you'd owe more damages because you'd be taking all public rights. So there's that aspect of it too. But I think the idea here is not to try to resolve the issue so much as just to put on the work on our work base the idea that maybe we take a look and see, do you need those public easements? Do we retain them or is there some ability to do something else, either turn them over or for a private road association or just relinquish the public easement? And then I think there are two pieces of that discussion of going forward. Would municipalities be prohibited from retaining public easements unless they agree to maintain them? And then where public easements are allowed, do we limit public use to motor vehicles and foot traffic, which is the case for statutory abandonment, but not for discontinuance. And all of the old public easements that were private ways did not have limitations to use by foot vehicles. And to motor vehicles and foot traffic. Only those that are created after about, well, okay, more recent ones that were created by municipalities post 76, where there's an actual layout to get to recreational areas or cut off lands. Only in those instances was there a limitation to foot traffic and motor vehicles. So you've got this really confusing thing of what kind of easement are you, when were you established, how were you established? Okay, you can use your motorbike, or you can, but at any rate, the idea is maybe there's something to look at for the future, as to say, okay, from here on out, you establish a public easement, you have to maintain it, or you, in the same way that a few years ago the legislature said it takes a year to take action on a discontinuance while folks explore the possibility of a private easement to take care of things, in which case a public easement wouldn't be necessary. There was also a question raised about, if the municipality doesn't maintain the public easement, do you get a property tax reduction? That's something that Roberta mentioned in early December, and also reiterated in her comments that were provided to us for today's meeting. So maybe that's another piece that gets looked at when we talk about the future of public easements. And also, just about everybody's building permit ordinance says that you can get a building permit to build on a public street, but then defines a street as being a road or right of way with public rights. It's not necessarily a town way where the town has the obligation to maintain, but that would also allow to build on a public easement where there's a public right of access, but no obligation to maintain. So you may have these old discontinued roads, and suddenly, because the land is cheap, people are building out there, getting building permits. It's all lawful. But then, you get 3, 4 houses, kids are out there. Hey, can I get my mail? No, you're not on a town way. Can I get school bus pickup? No, you're not on a town way. Can I get solid waste pickup and recycling pickup? No, I'm not, you're not on a town way. And suddenly there's pressure being placed on the town to do something. No one has a deed. The road has not been built to town specifications. The town doesn't really want to maintain it because it isn't built to specifications. The school bus won't run on it. It generates these kinds of conflicts because of the confusion. And our job is to dispel the confusion. So anyway, the idea of maybe looking at whether building permits should be issued on public easements going forward, or maybe even currently, or maybe with some kind of caveat, a little notification, by the way. I don't know, but these are some things that have been raised, and so we want that as being part of the work plan to talk about public easements. Doesn't mean we make a recommendation one way or the other, just do we talk about it? Okay. We talked about we had put together a draft survey for MMA to circulate, and that, although we agreed on the questions in the survey, it sort of fell through the cracks because we were called to the legislature to do some other things. And so is that something we want to talk about reinstituting? It's not anything that requires legislative intervention. The idea was just an easy survey of with regard to public easement information, maintenance inventories, just to find out what's out there, similar to what was done 10 years ago. Tanya, I'll talk. I can talk with you about that offline and provide you a copy of what we had talked about last year. Everyone seemed to be on board. It was a question of, who do we ask at MMA? How does this go? Is this a memo? Is this put in the townsman? Is this a flyer that goes up? We can talk about that piece.
Yeah, sure thing. Happy to talk about that.
Thank you.
My vote is yes, both on this one and on your previous one. I think they're things that need to be discussed.
So, and then the final thing on my list was because 4 and 5 go together, the survey and the idea of centralized repository for information for road inventories. Again, we'll discuss. We'll figure out, does it make sense, and how do we do it to make it make sense? The 6th piece may be building on all that. If we have more information out there about the status of roads, a place where we can send people to look, whether it's realtors, lawyers, consultants, then maybe clarification of the real estate road disclosure laws to zero in on things that are out there or that may be out there. Like if there is a road status inventory, and we know there's already DOT's map viewer that will tell you whether roads or portions of roads are publicly maintained. It doesn't say their legal status, but it tells you whether they're publicly maintained. And so, if we can, maybe we work with state and local government and real estate, the realtors to, gotta love it, my battery just went. Okay, the battery on my computer station decides to sing every now and again. I apologize for that disruption. But the piece is, once we can figure out what information is out there, where it is that we think people should look at so they can make educated decisions about buying properties, buying houses, then maybe we can work with the real estate bar and state and local government to recommend a change that would have them look at this information. So that would be number 6. There are some issues though are we okay with that one? That's sort of a cleanup when we get to the end of the other pieces. Roberta has a list, and the first on that she circulated, and Heather circulated to all of us at the end of the week, was with regard to the power of county commissioners to abandon roads. And basically it's to make the authority of county commissioners explicit and similar to that of municipal officials with regard to county roads. It used to be that county commissioners had jurisdiction over roads leading from town to town. They could lay them out, change them, abandon, discontinue. That changed in 1976 when Maine's road laws and highway laws were rewritten. And, excuse me. When in doubt, a circuit breaker works. And so the idea is if municipal officials can take care of it, now the county officials really have authority in the unorganized areas of the town of the state. And so that's where their road authority is really limited. And so the concept here is to require that that county commissioners have the same authority as municipal officials and put a cognate of 3028A and 3026A into Title 30A for county commissioners, and maybe just refer to those and say that they have the same authorities as provided to municipal officials under the other. So that would be the way to approach it. And I don't have any county representatives on today. We need Ryan, but assuming the county commissioners would like to be able to discontinue roads and portions of roads in unorganized territories, it makes sense that they clearly have the same authorities in those areas. So I'd suggest this is a reasonable thing to add to the work plate, maybe something we could all agree upon.
Can I just ask a quick clarifying question? Because this is one that's newer to me. Would that process also involve the Land Use Planning Commission, just in terms of the county commissioners decided they wanted to discontinue a road, but in the Land Use Planning Commission's plan, it had some, potential future development area in the unorganized territory? Would that be part of the process? I'm just thinking about the LUPC role in addition to the county commissioners.
Yeah. Roberta, since this was this is a detail perhaps, but
okay, we can talk about it.
But certainly, let's talk about it for a minute. Roberta, what do you think about LUPC having some review or input into this discussion?
I think that's reasonable. My concern was that the way 3028A was written when it was revised, it said that the county commissioners have the authority to abandon town roads. And they don't have any authority over town roads anymore. But there's nothing in 3028A that says that it applies to county roads. So why shouldn't counties have the same power over county roads that towns have over town roads? And I think, I hadn't thought about the LUPC being involved, but that's a good point.
No, I think that's fine. I think it's a good clarification. Okay. Is that all right with everyone? Just add it to the work plan?
Pete has his hand up.
Okay.
Yeah, Jim, I just want to say that out of the 16 counties, there's 10 that have road responsibilities in the unorganized territories. The other 6 don't.
Thank you. Great, thank you. Roberta's second issue, I don't mean to be speaking for you, Roberta. I'm just trying to summarize a little bit here. With regard to 3028A, you have some suggestions to add to it. For example, there's a presumption of abandonment of a townway that arises if a municipality has not spent public money to maintain a road for at least 30 consecutive years. It once upon a time was the 30 consecutive year period from 1946 to 1976. Now it's any 30-year period after 1946, most likely. The court hasn't added that last gloss, but I think that's the right call. It can be rebutted by evidence that the town has maintained the way. And then the question is, but the law does say that isolated acts of maintenance don't rebut the presumption. The question is, what are isolated acts of maintenance? And that has created several court cases. Does winging back the snow every winter constitute an isolated act of maintenance? No, probably something on a regular basis wouldn't. But if you dump 3 loads of gravel over a 30-year period, is that an isolated act of maintenance? Probably. But these are all the factual discussions that make everyone, municipal officials and landowners, crazy. Because it takes tens of thousands of dollars to go to Superior Court, put on your realtors, put on a public works director, your road commissioner, all of these witnesses, get a title abstractor to talk about who owned Jones Farm back and how the intervening owners are and where it was located on the layout. It can take a 2 or 3 day trial. It can cost $100,000. And if you win the case, you don't get your attorney's fees and costs. Everyone pays their own fare on this one. So that's why these road issues can be so thorny, so expensive, so divisive. You get heated tempers over all this. And so this proposes to define that no more than 3 acts of maintenance at the expense of the municipality would be isolated acts of maintenance. So it looks at quantity, not necessarily quality of the acts. I don't know if that's right, but that's and then a requirement of retaining a public easement if the townway provides the sole access to any property and it's being discontinued or being abandoned here. And these are some tweaks to Title 28, Title 23, Section 3028A on statutory abandonment that do potentially work some burdens for municipalities, but is it worth adding to the discussion, to the work plan list for the year?
Well, as you said, if we can clarify some of these things, it might avoid expensive lawsuits.
Maybe, and well, do you want to try to add this to the list? We can discuss it and see if it makes sense and what we can and can't agree to. Okay, we'll add it to the list. It's the third one would be, there's no page number, so I can't But the question is, how do you prevent towns from circumventing the law by saying a road was already abandoned under the old law but not recorded? Or should that be allowed as long as there was a 30-year period of non-maintenance before the law changed? This is, again, you're thinking about statutory abandonment where there wasn't a requirement of a recording of a decision by the select board or the town council or city council that a road was abandoned. So yeah. If there's a discontinuance, there's a law that's been in place since 58 or 59 requiring a certificate of discontinuance to be recorded in the registry of deeds. Everybody knows a discontinuance happened. It wasn't always recorded, to be honest, but there's a requirement. And I think in more recent years, it's been more faithfully followed. With regard to statutory abandonment, there's always been a requirement that the select board or the council vote as to whether they think the town has not maintained a way for 30 consecutive years, and therefore the road or a portion of the road is presumed abandoned. It's only in more recent years that there's, like the last 5 years, 6 years, that there's been a requirement that that vote be recorded. And it was only 20 years ago that it was changed so that that vote could be appealed to the Superior Court. So what happens to decisions that were made that a road is presumed abandoned before the requirement came into being that the decision actually be recorded? Is that what you're talking about here, Roberta?
Yeah, it's actually been argued by a number of people that abandonment was just sort of automatic, that it was presumed that if the road hadn't been maintained for 30 years, it was abandoned. So sometimes there wasn't even a vote by the selectmen. And then even when they put in the requirement to file a notice with the registry of deeds, the law still says that lack of any filing of a notice does not necessarily mean the road isn't abandoned. Because if they haven't maintained it for those 30 years, it's abandoned whether they voted on it or not. And so the issue here is, how do you know whether a road was abandoned before the law changed and it just never was recorded? Do you have to then go through the process of abandoning it again and go through all the new requirements for notifying landowners and making sure that everyone will have access? Or can a town just say, oh, we abandoned that way back in 1982 and just never recorded it, so now we don't have to notify the landowners? So that's the issue here.
Sounds like that's something that goes with the overall discussion of 3028A, not just the specific changes you had, but also this little gap issue, how to deal with it. So I think if we're going to talk about the one, we can talk about that within it. The separate issue you have is whether the discontinuance statute should be separated, one for townways and one for public easements, to make it easier to, if a town takes an inventory and says, well, we don't need these public easements, do we also want the 1 year wait on those? Do we want to make it easier? Do we want to make it separate? Is that basically what you're looking at, Roberta?
My concern is that, well, I think it's a great idea to allow the abutters to say, we want this to be a private easement in common. We're willing to grant each other that easement if we can get rid of the public easement. But it's made discontinuance so complicated that, that 1 year waiting period and all the notifications to landowners and trying to explain to them what their rights are to make up this shared private easement. I'm afraid that a lot of towns are just sort of throwing their hands in the air and saying, oh, it's too complicated to discontinue it. We'll just leave it and hope that it goes away by abandonment after a number of years. So it's just leaving roads in limbo. And if we can make this simpler for the towns, make it, go back to the way discontinuance was before that was added in, and say, okay, you go through the discontinuance process. Now, if it would have left anybody landlocked, we have to keep a public easement. But then what do we do with the public easement? You can tackle that next. And I think by separating the two, it might make it simpler both for the towns and for the landowners.
That's something that the commission wants to talk about.
I'm good with that.
Okay. Then 4 on your list is there needs to be a method of facilitating extinguishing public easements so that owners of abutting land are not burdened by the cost of maintaining these roads for public use. Further, if towns must be allowed to have the final vote, then there should be some sort of incentive for the towns to give up roads it really no longer needs enough to justify the cost of continued maintenance. I think this kind of goes with the discussion of public easements that we talked about already, the broader issue of going forward, what do we do with public, do we require public easements to be maintained, to be retained unless, if they're needed for access, and require them to be maintained by the town? Those sorts of discussions. Does it make sense, Roberta, to group that in with that overall public easement discussion?
Yeah, I think it does. This also ties into something that Matthew was saying earlier about towns not wanting to give up roads that they might need in the future. Part of the problem is that a lot of towns aren't accepting any new roads because it's so expensive to build and maintain roads these days. So even if they hang on to it, they're hanging on to it on the basis that the abutters are going to maintain it. And if you're going to do that, might as well make it a private road. We've got private roads that are privately maintained, and it's understood that they're never going to be brought up to town road standard, but they still provide access for those landowners. So if it's a question of future development, yeah, you can have future development on a private road, but do you have to hang on to the public's right to it in name only, but not providing any maintenance to it? Does that really make sense?
So I think that goes with the larger discussion of public easements, and so we'll put all that together. The next one that you raise is road inventories, and I know that John Monk joins in that idea, and we've discussed it already. I think this gets tied in with 4 and 5 on my list from the executive summary draft report. So if that's okay, we just make this all part of the road inventory discussion. Is that all right? Failure to provide safety and convenience. This is a head scratcher. And it's a question of whether this even comes within our jurisdiction. We're supposed to look at abandoned and discontinued roads and the problems that have arisen, the confusion that's arisen because people don't understand those terms and what public easement means and private ways and private roads. And those are the sorts of things we've been asked to take a look at. With regard to a town way, state law has always said that a municipality has the obligation to maintain a public town way, safe and convenient for passage by travelers with motor vehicles. Really easy to understand. It's the same standard, applies to every municipality, but this session, for some reason, that standard was changed. And it makes that subject to local conditions. I don't know what that really adds to discussion. More importantly, it used to be that if you lived on a town way and you went to the town and you asked to have the town way maintained and it wasn't being maintained, 3 or more persons who lived on that road had a right to go to the county commissioners and ask them to order the town to maintain the road. And if that wasn't followed, if there were issues, that could always go up to the Superior Court. This year, that right of appeal to the county commissioners was repealed. And in its place, a municipality may authorize its Board of Appeals, which normally handles zoning matters, to hear petitions about maintenance of town ways. It may, but is not required to. And so, and the county commissioners are out of the business of hearing these petitions altogether. So there may or may not be any route short of mandamus to the state superior court to order towns to follow their obligation, which now is a little more subjective than it used to be. And I don't know what the impetus was for this legislation, but it's now made things a little more confused. But it's not abandoned and discontinued roads. And so Roberta's raised the issue. I think it makes sense to put the law back to the way it was and say, oops, we didn't mean it. I do understand that that language that's in there came from MMA. I don't know what the reason was. And I'm not trying to throw anyone under the bus saying that. I just don't know.
Can you
yes.
tell me what the bill was? So I can just look back at our
Yeah,
records.
let me see if I have it right in front of me.
Okay, or you can just email it to me afterwards. I just want to look into it a little bit.
Yeah, it's LD 1562.
1562.
Chapter
Thank you, guys.
395.
Okay.
The issue here is that that has been a great way of preventing roads becoming abandoned. I can give the example of the Bowen Hill Road in Liberty. There were people on that road who complained to the town for years that the road is deteriorating, you need to fix it. And the town just ignored them. And if they had known at the time that sections 3651 and 3652 existed, they could have gone to the county commissioners and the county would have come out and looked at the road and said, yes, by record, this is still a town way and it's in horrible condition. You need to do something about it. And then, if the town wanted to say, well, we need to discontinue it, then they would have had to go through that process because they hadn't reached the 30-year period yet. But instead, because nobody knew about these statutes, their complaints were ignored, and they were ignored for so long that finally the town was able to claim the road abandoned, and the road never did get fixed. I've seen other places where a road was starting to deteriorate, the town was refusing to do anything about it, and I've told the people, look, here are a couple of statutes you can try. And they have gone through the process. The county has come out and said, yeah, this road needs to be fixed, and the town fixed it. End of problem.
So there are really two issues here. One of them being that we have this new standard. It used to be safe and convenient for travelers with motor vehicles, and now it adds to it based on existing roadway surface and the season of the year. That makes it a little more subjective, possibly. And so you have to notify the municipal officers or the county commissioner that a way is not safe and convenient. The municipal officers can then evaluate the risk and decide whether or not it should be repaired. Then you can go to the Board of Appeals, but it's not required that the Board of Appeals handle these. And I think people would be leaving boards of appeals in droves if they knew they had to hear road cases. It says the legislative body of a municipality may appoint the municipal Board of Appeals to receive a petition of a defective town way. And then it talks about how people can petition them, what's done. And boards of appeals are there for variances in land use disputes, not road matters. Once in a while, they go tax appeals if municipalities don't want to appoint a separate board of assessment and adjustment and review. But that's anyway. So those are the issues, not having a right of appeal and then having that weird standard. The old joke goes that with regard to a town way, a town has to maintain it safe and convenient unless it stops doing that for 30 years, in which case it's now abandoned. It just has to stop doing what it's supposed to do for long enough that it no longer has to do it anymore. Sort of a sad joke, but there you go. And so the idea being that if people don't have a reasonable right of appeal on road standards and that time passing by takes away their public road rights, that's not necessarily a fair situation, but still, I don't know that that brings this issue necessarily within our gambit, but I
Could we
just
always
ask,
give a
maybe we want to take a
recommendation on
look
it?
at it.
I know it's not in our purview necessarily, but is it something that we could at least like take a look at and give a little bit of an opinion on, recommendation?
I think state and local government would welcome it.
Okay,
They like
that
using
sounds
us as,
really reasonable to me.
yeah, they like using us as their sounding board. And okay, so I'll add that to the list.
So I was pretty involved in the way this one started out because this started down in the town of Lowell out east, where an out-of-state guy bought some property on a gravel road and thought it was full of potholes. And I ended up going out there within a day or two because I was headed up north. And honestly, I couldn't even find the pothole. And I was out there with the selectmen. One thing led to another, and the board felt that they ought to get their local legislator, who used to be on the board of selectmen there, to submit that bill 1562 in its original form. And then it got tweaked as the session went along to what it is today. And I could comment more on the history of that, but don't have to do that right now.
Yeah, sometimes these changes have unintended consequences, and that may be what's going on here. So we'll add that to the list and see if we can take a look at it and suggest some changes to make this work for everybody. And the next one that Roberta raises is the taxation issue, which we talked about as being part of the overall discussion on public easements. If you live on a public easement and the town doesn't maintain it, should you be able to ask to have your taxes reduced? And that's part of that big, larger discussion of public easements. Do we like them? When do we like them? Should they go away? Should we give opportunities for them to go away? And then should there be some tax consequences? That can be part of the discussion. Doesn't mean we recommend them or don't recommend them, but part of the discussion. Is there anything that I have left out from this?
Matt has his hand raised.
Oh, I'm sorry. Matt, please.
Yeah, I'd make one more recommendation. We should meet in person, have coffee, donuts, have a good old time when we get together, you know?
If we can get the legislature to get that per diem going with the governor signing that bill.
We tried to bake sale Matt to get that money, but it didn't work out.
I don't mind Teams meetings, but it is nice to get together once in a while and see people face to face and
it is
everything. So
it is. So let's plan on that in the new year once we get this report done. How's that?
Yeah, we'll have a big Christmas party when we solve all the problems.
Yeah, there we go. All right. So for right now, I have a list. If somebody has an idea that they want to bring up, shoot it off to me. But I think we've got a fair amount in our parking lot right now to deal with for 2026. For me and my successor to deal with in 2026. And so we'll get that. I'll include all of those changes to the work plan and get that together in the draft I send back to you after you give Heather and me your comments on the report. Okay, so you comment on the draft report we sent to you. Know that we are working on updating the work plan based on today's discussion. So that's going to change to incorporate what we talked about today. But the rest of the report, please provide your comments, and we'll get that all out. The idea being that you will have it in time to review it before we meet on the 16th for a vote, and we'll meet online. But we will resolve to get together in person to say hi, because it would be good to see everyone. It's been a while. And like I say, if the governor signs that bill, we'll have some money to pay per diems and we can do things like that. Right, Heather?
I hope so. It would be nice.
All right, we've been talking about this since the commission's been started. It just hasn't happened. The legislature promises funding and it hasn't come through. So we'll cross our fingers on this one that the governor signs last year's bill and that we get the funding. Anything else for today? Public comment?
Yeah.
Public comment?
I'm gonna set the timer though, just so you know, for 3 minutes. And then, I only ask that people be respectful.
Yeah.
Yeah, I'm David. The U.S. Constitution requires in Article 6 that the Constitution, laws made pursuant to it, and treaties are the law of the land, and that the judges of every state shall be bound thereby. In short, the courts have to reference the federal level law first because we're all in the same country. Then it goes on to say that anything in the constitutional laws of every state, to the contrary, notwithstanding. In other words, have no standing. So the judges still have to reference the U.S. Constitution in relation to the laws. Now, why I say this is because when in Jordan versus Canton, the state referenced the state's constitutional law that said you can't, that you cannot take private property for public purposes. That's consistent with the U.S. Constitution. So maybe it's a little irrelevant, but they should have made their reference to the U.S. Constitution first. Now, when we have a public road, under no matter what guise there is, that isn't being maintained by the public and is held by the public, it is blatantly unconstitutional. Can go into all the arguments for that. To the gentleman who's working for the town, representing the towns, good points. Even in the town of Fayette in 1946 time, because of that action, they said to the townspeople, after they said to the purchaser of my land that this road was discontinued, they said, but the roads were legally closed. With the provision, the town of Fayette retains the right-of-way so that if in the future they should be reopened, the town won't have to purchase the property. Well, where was that requirement in 1946? I go through the legality of everything that was done in that should have been caught by the court and said, no, it was unconstitutional and it should revert everything back. This is a real condemning factor for the towns. If you turn around, and I'm getting ready to go to the federal district court, so this does become a federal issue because the state can't understand that the main principle of what's going on is unconstitutional. We should not have changed a terminology to public easement. We can have public easements that are sewers, power lines, etc. Are people allowed to drive on them? We have aqueducts in some places. We have canals. You can't drive on them. But what do? We make a law that says a public easement. And that was made 5 years after I purchased my property. And the state Supreme Court made it ex post facto a requirement of what the county commissioners did in 1945. It's ridiculous. This is why I go ballistic when I hear a person who's an attorney saying to me that we can ignore the U.S. Constitution. I buried 57 people for the United States Army. And I'll tell you what, I learned what the Constitution said. I may not have totally understood it, but I really did. And I had to go to all those people, crying tears, etc., and make them feel as though they were being treated properly. And damn it, I did too well. And it drives me nuts ever since. So I want you to respect the Constitution that I swore to uphold. And anyone who isn't in agreement with it, as we looked at it in the service, you're my enemy. Well, I don't really think you are.
So that's been 3 minutes, David.
All right. I just think you people need to take that and respect it.
Okay, thank you for your
David.
comment. And if you want to send us a written thing, that'd be great. Thank you, David.
Yeah, well, Roberta will have to type it. I'm sorry about that, but
All right, thank you.
Okay, thank you. Anything else for today? All right, I'd like to thank you all for your work today, for commenting, and Heather and I will turn that around as soon as we get your comments, and I'll work on getting that work plan integrated. Thank you very much. We'll see you on the 16th.
Thanks,
Thank you.
everyone. Have a good day.